Hello, so let's get started. In this lecture, we begin our conversation about general defenses to crimes. For much of the semester, we focused on the elements of an offense, that is, what elements must the prosecution demonstrate beyond a reasonable doubt in order to obtain a conviction. And we know that the government's burden is to prove all elements of a crime beyond a reasonable doubt. In Chapter 9, we turn to a discussion of defenses, particularly those in which the defendant admits or concedes that the government has met its burden of proof, but nevertheless argues that he should not be held criminally liable because of the particular circumstances of the case. So you should have reviewed pages 501 to 507, which provide some introductory material with respect to defenses as well. You should have looked at the video. I posted the link on Twin that also gave you an overview of defenses, but I want to take a moment here to highlight a few important points. So taking a look at the first slide, the question we deal with is, what is a defense? Broadly speaking, a defense is any set of identifiable conditions or circumstances that may prevent conviction for an offense. More particularly, there are 5 types or categories of defenses. They're listed on the right of the slide. So the first is failure of proof or insufficiency of the evidence. In other words, that the government has failed to prove the elements of the offense beyond a reasonable doubt. A second type of defense is an offense modification. Here, these defenses reduce but do not completely eliminate liability. So, for example, heat of passion or provocation or EMED are partial defenses. They reduce liability from murder to manslaughter when appropriate. A third category of defenses include justifications. And here we would include self-defense, necessity, or choice of evils. In these scenarios, we determine that a defendant has not engaged in criminal activity, even though all of the elements of the crime have been satisfied. We conclude that the defendant has engaged in desirable or acceptable behavior, or the behavior has not resulted in a social harm. Hence, no crime has occurred. A fourth category of defenses include excuses. Here, we would be referring to insanity or diminished capacity or duress. Here, again, the defendant has engaged in undesirable criminal activity, but he is not blameworthy and society chooses not to hold him responsible for that activity. A punishable crime has not occurred, so to speak. And then lastly are those defenses that fall under the category of public policy defenses. Here, for example, we may be talking about some sorts of governmental immunity, such as diplomatic immunity, statutes of limitations, or defendant's incompetency to stand trial. Here, the defendant is guilty, his conduct is blameworthy, and it is not desirable, but we choose for public policy reasons not to convict the defendant. So, for example, with respect to diplomatic immunity, we're concerned about the relationship between 2 foreign entities, and we want to preserve that relationship, and we do so by not prosecuting certain foreign nationals for their crimes. The most common of these defenses, and the first line of defense, is insufficiency of the evidence or failure of proof. This is a defense we have already seen many times throughout the course of the semester, as we've seen challenges on appeal to the sufficiency of the evidence. Again, here, the defense relies on a proper determination of the elements of the crime by reference to statute and case law where necessary, as well as the ability to craft an argument that the government has not met its burden to demonstrate that the facts prove guilt beyond a reasonable doubt. Because we've talked at length about this defense, we won't talk about it specifically anymore. But please always keep in mind that this is the first and most common defense that individuals raise. As well, we've already talked about the common partial defenses of heat of passion and EMED, so we won't talk about those anymore. We also will not talk about public policy defenses, but you should be aware that they exist. For the next few lectures, we'll focus on 2 of the most common justification and excuse defenses, self-defense and insanity, which we label affirmative defenses. All right, turning to the next slide, the question becomes, well, who creates defenses? This is a topic wherein criminal law and adjudicatory criminal procedure intersect. The answer can be quite complicated, but here are some basics, some of which we previously touched on. Just as the legislature has authority to criminalize behavior or enact crimes, the legislature has authority with respect to defenses. Legislatures set out the elements that must be proven to find guilt. As well, they may set out what constitutes a defense and the elements of those defenses. They may also set out sentencing factors or elements and determine who bears the burden as to any of those matters. Thus, in contrast, the role of the judiciary is to interpret the meanings of terms and statutes and determine the constitutionality of defenses. Another important point to be aware of is the burden of proof. Who bears the burden of proof with respect to defenses? When we speak of a burden as a legal term of art, burden has two meanings. One is the burden of production, and the other is the burden of persuasion. We've touched on these briefly earlier in the semester, but let me just remind you. The burden of production is the requirement that a party produce enough evidence to go forward with the case or the charge or the defense. The burden of persuasion is the requirement that the party convince the fact finder, usually the jury, but sometimes the judge, of your position, that your argument or your claim is true. How might those burdens, the burdens of production and persuasion, be divided for defenses and their elements? It is possible that the legislature might place the burden on one party or divide the burdens between parties. So first, let's consider common law. First, you consider the elements of the crime. Generally, the burden is always on the government. The government must produce enough evidence to establish the elements and then persuade the trier of fact that the defendant is guilty beyond a reasonable doubt. And it must do so during its case in chief. In some instances, the legislature also imposes on the government some obligation to present evidence respecting a defense, especially where those issues concerning the defense are interconnected with the elements the government must prove. So, for example, consent or non-consent for sexual assault charges. Here, the government is often obligated to prove non-consent, and to the extent the defendant has raised some issues of consent, the government will also bear the burden for disproving consent. Another example, when we are referring to heat of passion or lack of provocation claims, the government, so long as the defendant raises the issue appropriately, must disprove the heat of passion or provocation. If the government fails in its burden of production and persuasion, then the judge must dismiss the case. Another circumstance we've seen, as I've mentioned before, appeals in which the defendant challenges the sufficiency of the evidence. Defendant argues that the judge should have not permitted the case to go to the jury as a legal matter. Rather, the defendant should have been acquitted because no reasonable juror could convict the defendant based on the evidence. So here again, the government is required to produce sufficient evidence and bear the burden of persuasion, and if it fails to do so, then the case must be dismissed. So contrast this circumstance with affirmative defenses, which we're discussing at this point in the semester. Here, two scenarios may occur. First, a defendant may bear the burden of production of evidence during its case in chief. The standard for defendant's burden of production may vary from a scintilla of the evidence to slight evidence or credible evidence or substantial evidence or some other similar type standard, but it is clear to say that the standard is not beyond a reasonable doubt. In this circumstance, if the defendant bears the burden of production of evidence, the government may still bear the burden of persuasion and will likely have to offer evidence in rebuttal. If the government does not disprove the defense beyond a reasonable doubt, the jury must acquit. In another scenario, with respect to affirmative defenses, The defendant may bear both the burden of production of evidence and the burden of persuasion during its case in chief. The burden of persuasion, however, is only by a preponderance of the evidence. The defendant's burden is never and is not beyond a reasonable doubt. That remains the government's burden. If the defendant fails to meet its burden of production and persuasion in its case in chief, then the defendant will be convicted. Again, I can't give you clear, bright line rules or tell you which is the majority approach. Whether or not the defendant bears the burden of production and burden of persuasion on affirmative defenses varies by jurisdiction, and it varies by the particular defense. Okay, so those are the introductory overview comments with respect to criminal defenses. In the next recording, we'll take up self-defense.